today our speaker, Catherine Jasserand, who is recently joined CITIP as a postdoc working on facial recognition technologies in the public spaces. She holds a PhD on biometrics and privacy from Groningen University. She has also studied in France and the US, and she has also worked in European institutions and the private sector. Catherine today will be talking to us about the Clearview AI, a company with a specific software that collects billions of pictures from the internet and that then makes them available to law enforcement authorities. And Catherine will discuss the legal implications and more focusing on EU data protection rules. So Catherine, the floor is yours. Looking forward to your talk. We don't hear you, Catherine.
You don't hear me? Yes, sorry, I was, good morning, good afternoon, everyone. You don't see me, right? No, you see me now. So good afternoon, everyone. I'm going to talk about the case Clearview AI because it's a case that has raised lots of public attention, but also regulators' attention. And I think as citizens and users of the internet, we are all very concerned by what Clearview AI is doing with our images. Just a few words about where I work. So I work at CIF. We are currently 80 full-time researchers and involved in interdisciplinary programs and projects that are funded at European and national level. I think I will switch off my camera. It will be easier maybe for the connection. Our research unit exists in 30 years, and we are working a lot on new technologies and privacy, but ethical aspect, legal aspect, but also intellectual property and internet law. So my own research is a Marie Curie fellowship. I'm interested in the use of facial recognition technologies in public space. And I'm looking at 4 countries, the UK, the US, France, China, but especially in the impact of the use of facial recognition technologies on the rights to privacy and data protection. And that's why we'll cover as well these rights in the presentation. So let's move to the talk. I'm going to give you a bit of context how Clearview AI practices were revealed and by whom. I will explain the functioning of the platform, and that's also the way I understood it. And maybe afterwards we can discuss about it, because I think that among you, there are some computer scientists that might know better the functioning of the platform that I do. I will spend quite some time on the data protection issues, Clearview AI, and the use by law enforcement authorities in the EU, because according to an investigation that several police in Europe have tried the tool. And then I will give you a brief overview of legal actions and complaints against the company. On this, I have to mention that I've tried to be as exhaustive as possible, but it might be that I miss some actions that are ongoing if they haven't been reported by the media as well. Let me know if you prefer me to show my camera, or if you find you can send or write in the public chat if you prefer me to show my face. It's just for a question of connection, because I think it's not so good otherwise.
Indeed, Catherine,
but I'm
there
fine
is
otherwise.
a bit of a connection problem, so I think best to keep it off.
Okay, okay. Let me know as well if you lose me. So let's move to the context. May know that the New York Times made an investigation and actually published its findings about Clearview AI January 2020. So that was there was a public outcry after this revelation. It was a lengthy article about what company did with images photographed that it found online. So it's a startup. It was a small company, a startup, which they decided to grab as many pictures as possible from different social media and professional websites as well, such as LinkedIn. Quite soon after this investigation, several companies asked Clearview AI to stop using or scrapping their platform. That was the case with Twitter and Facebook as well. But what is interesting in this article, and I recommend that you read it if you're interested in the topic, is what the New York Times wrote. So it was a tiny company that created a groundbreaking facial recognition app. And the way it works is that you take a picture of a person, upload it, and get to see public photos of that person. So for comparison, with links to where those photos appear. The system whose backbone is a database of more than 3 billion images that Clearview claims to have scrapped from Facebook, YouTube, Venmo, and millions of other websites. I say LinkedIn, but there are many other websites that were scrapped. Goes far beyond anything ever constructed by the United States government or Silicon Valley giants. And I would say as well that it goes beyond that what we have ever known until now. I want to say that I was surprised to read in an interview that the founder of the company gave to Wire that as of the 4th of October 2021, company has more than 10 billion images in its database. This is quite surprising if you take into account the actions that have started against the company. But it seems that the company is for the moment unstoppable. So we'll come back to that. So about the functioning, I found that maybe the best way to discuss about the functioning is to explain what Clearview AI published on its website and how they describe as well the tool that they make available to law enforcement authorities. Having said that, I want to say that it's not only to law enforcement authorities that they make the tool available or that they make available. Private companies also tried the tool. It was disclosed, but it seems that now they are focusing really on law enforcement authorities. So if you go on the website, you will see that the functioning, the way it works, is divided into 4 steps. And the 4th step is actually when the user uploads a picture. So you upload a picture, and afterwards, picture will transform and search against already existing picture in the database. It's the example that they give. That was the picture uploaded by the law enforcement authority, and then you have a comparison which is made with other pictures. And this database, the problem, the constitution of this database. Afterwards, a matching is made together with some URL or other links, because Clearview does not only collect photographs, it also collects data that includes title, URL, geolocalization, any type of information that can be associated with the photograph. And then the last, of course, step is the result, which is a return to the user. So here you see that you have several photographs of the same person that are returned. So it's said clearly that it's a tool to facilitate the work of law enforcement, but it should not be used as an evidence. Having said that, I want now to explain it based on the complaint that none of your business, it's an Australian civil liberty association which has made a complaint against Clearview AI before the Australian Data Protection Authority. And they wrote a very detailed complaint. And in this, what's interesting is the way they describe the technology, because and the way the database was constituted. Because beside what I found on Clearview AI, there is not that much which is available concerning this database. So Clearview AI use an automated image scraper. That's the wording that they use to search the internet and all the websites that they are publicly available. I will come back to it. And images where faces are detected. And this image, they are collected together metadata. So what I say, information with the images, and everything, these original images and the metadata, they are stored on Clearview AI. These images, they are transformed. So the facial features that are useful for recognition purposes will be extracted and processed. So through an image processing. And I've actually copied what was written in the complaint, is that for each image collected, every face contained in the image is scanned and processed to extract its uniquely identifying facial features. So this is a very important term, uniquely identifying features. And the faces are related to numerical representation that are referred as vectors. Afterwards, these vectors, they are, and that's the next step. So they are 12 points that are used for recognition purposes. But afterwards, these vectors, they will be transformed. They will be hash, mathematically transformed for identification and future identification purposes. So that's the hash version of the images, which is compared. So that's what I explain here. And once again, it's based on the complaint. It's when a user uploads a picture, the platform will analyze the image, extract the features, and hash them to compare with already existing hash vectors. But the result which is returned afterwards to the user, they are the image. They are not the hash value. And this is important because you will understand when I discuss about the complaints that have been made by the Data Protection Authority. I will explain you. I will reuse actually this hash vector in a specific context. So this is the technical functioning of the database as well. And the problem, it's actually all these faces. So all these faces, so as I said, just after the revelation, you had several legal complaints and action that I will explain. And the problem is that all these faces from the internet without any consent and without any legal basis, as I will explain. After the New York Times revelation, there were several complaints in Europe. For example, in Canada, the Data Protection Authority has already made a decision. In Australia, it's the same. In California and in Illinois, there are some legal proceedings as well. And in Europe, only the data protection in Hamburg has issued an order, a very restrictive order, whereas the Swedish Protection Authority made a decision against the use of the tool by the police, but they are in Europe ongoing actions, and there should be a coordinated actions by data protection authorities to actually reply to these complaints against Clearview AI practices. So what I will distinguish is the practice by Clearview AI, meaning the collection of all our data, and then the use of the tool by law enforcement authorities in the EU, because the legality is different for these two different type of processing. So data protection issues, you might be aware of that. We have two main instruments In the EU, a general instrument, which is the General Data Protection Regulation. And the question is that, is it applicable to Clearview AI practices? Because Clearview is not established in the EU. So here it's an issue of territoriality. And then there is a specific instrument in the field of law enforcement. It's the Law Enforcement Directive that needs, however, to be implemented at level. And the question is whether there are some specific provision in this directive as implemented at national level that will allow law enforcement authorities to use the tool. But this is a second aspect. So the first aspect is about the practices, and the first question is the editorial scope. So it's a bit legal, but I try to make it simple for you to understand. Then I will discuss the nature of the data collected by Clearview AI, the principle and rights that Clearview AI most likely infringe with the processing of our data. The scope of the GDPR, of course, the GDPR, it's an instrument that regulates the processing of personal data in the EU. So this is the rule, and the controllers or processors, so that's the terminology that we use. Controller is the entity in charge of the processing. Well, in our case, Clearview is the controller, and the processor is the entity acting on behalf of a controller. So if they have an establishment in the EU, it's enough to apply the GDPR. But if they don't have an establishment, there are two possibilities, even a third one, but that I didn't include. It's in case you will apply the GDPR due to international public law, such as in an embassy, for example. But let's focus on the two aspects that are important here. The GDPR that applies to the processing of personal data, it can apply to entities that don't have an but they are offering goods or services to individuals in the EU, or they are monitoring their behavior as far as in the EU. So looking at the pictures that were collected from individuals in the EU, we can actually say that Clearview AI, it doesn't have an establishment the way it's defined in the EU. Concerning offering goods and services, it's offering goods and services to law enforcement, so we could actually question whether it's also offer goods and services to data subject, but I think it's not the most interesting provision that will apply to Clearview AI. It's more the monitoring of the behavior of data subjects in the EU. So what is important to know is that it's not the place of residence. It's not if you are an EU resident that it will apply to you. It could apply to a foreign citizen located in the EU, and its behavior was monitored when he was in the EU. So that's the location and where the behavior happened. For example, if you track a person on the internet through cookies, and the person in the EU has access to the internet in the EU, and you track the person because she's in the EU. That could be a very good example. Or if you are doing a behavioral study based on individuals' profiles, and then you have a link to EU, it's also a very good example for monitoring behavior of data subject in the EU. On this, we have actually an opinion from the UN Data Protection Boards, Opinion 3 2018, on the territorial scope of the GDPR. If you're interested, you can more examples. But now if you take the example of Clearview AI, and based on the Hamburg Data Protection Authority's order that was published in January 2021, the Data Protection Authority considered that Clearview AI monitors the behavior of data subjects in the EU because the company records the behavior of individuals, store behavior of data, because, and I think this is the most important argument, the tool is to identify individuals. So thanks to so it's to identify individual. And I see that my screen, sorry, apology. So the purpose is to identify individuals. Then the recording, storage of publication, profiles, accounts of users, so all the information as well linked to a photograph. The purpose is to create a profile to be able to say to a law enforcement authority, we know who the person is, and we match it with an existing picture, and we also send you all the information that we have about these pictures. The company also archives picture over time. Finally, I'm not sure that this is completely irrelevant, but the Data Protection Authority said that the complainant, because that was a very specific case, was also physically present in the EU when he accessed the internet. But this, you could say that it might not apply to everyone, or you cannot be, you might be able to this condition all the time. But I would say this condition most important. And it's for that reason that you could say that individuals in the EU are targeting the same way individuals that can be in Canada, in Australia, or in other countries are targeted because they are there and because it will bring as well to law enforcement authorities. So I think this is a very important point. And so far, we just have the order from the Hamburg Data Protection Authority to confirm that Clearview AI, through its processing of practices, monitors the behavior of data subjects in the EU. So we have to wait for more decision for confirmation of this intention as well. But on this basis, then we can assess which kind of provision it will trigger provision of the GDPR. And the first one is the nature of the data, because of course, if the data that Clearview AI collects are not personal data, there is not even a discussion about whether the GDPR would apply. So once again, the data, they are the images and the associated information collected and processed, and they are not only personal data, but also biometric and sensitive data, and I'm going to explain why. So first of all, they are personal data the way we define it in the GDPR, meaning any information relating to an identified or identifiable individual. And the threshold of identification is very low. It means simply that you are able to distinguish a person from a group, to single out. So it's not even about knowing the name of an individual. So a photograph in itself, it is sufficient to identify someone, is considered as personal data. If you don't have a sufficient definition for a face to identify someone, of course it will be a decision. But the photographs that are scraped from the internet, they are targeted since they are only photographs that contains human faces. So they are definitely personal data. The other information that are collected, they could be also other type of personal information collected, such as you can have a name as well, which is collected and associated with a picture, but you could have as well a geolocalization, you could have a title, and all this information together, they could be used to indirectly identify the individual. So for that reason, I think there is no doubt that the data collected, a photograph for sure, and certainly most of the information, extra information, are personal data. What is interesting is to discuss actually when they are biometric data, this photograph. So according to the GDPR, the personal data that are processed, so they result from a technical processing, and when they are processed to allow or confirm the unique identification of a natural person, and the example which is given is facial images, these personal data, they qualify as biometric data. So it's a special category of personal data that we have. But to draw your attention to Editorial, which is not binding, but which explain the definition of biometric data, and it concerns photographs. And photographs, they are not considered all the time as biometric data. They become biometric data when they are processed to allow the unique identification or authentication of a natural person. So they need to be processed for biometric recognition purposes. Here, and that's also what you can read in the complaint written by Noib. The data that scrap the internet, they are purely, they are merely photographs. So these data will not be considered as biometric data. But once they are processed, the features are extracted and then converted to be compared for identification purposes. These data that are transformed, they are biometric data. And this is very important because biometric data that are used to uniquely identify a natural person are considered sensitive data. So let me explain what is sensitive data. Sensitive data category of personal data that reveal very private information. It can be about your health, about your ethnicity, about your political opinions, religious beliefs. So because these data are considered very sensitive, very personal, very private, they are subject to a higher level of protection. Normally, they cannot be processed unless you have a specific exception that can apply. And concerning biometric data, so if they are used to identify with the purpose of identifying someone, they are sensitive. So here there is no issue. I mean, the photograph collected from the online sources, they are not biometric data. They could still be sensitive if they reveal, for example, a health condition or ethnicity. From a picture, you could see some sensitive information, but they are not biometric data. But the data that Clearview AI process for the comparison purposes, these one are biometric data and sensitive data. So I'm saying that because I'm going to explain afterwards the different principles and the legal grounds that apply to personal data and sensitive data. Let's go back one step before. The images that were collected by Clearview, contrary to what Clearview AI argued, they are not freely available. They are not freely reusable. So it's not because you can find them online that, and even if they are on a public public web page, doesn't mean that it has that you surrender all the rights concerning data protection as well. And the website which they wrap, they are accessible, they are public accessible, but they are not publicly available. I think that we should keep as well the expression publicly available to public sources because information that public authorities hold, actually these public authorities in the EU, they have the obligation to make information public, and we say publicly available for public information released by public sources or public authorities. But this doesn't mean freely reusable. The right to data protection still applies, And I want as well to say that you also see that very often there is a confusion between copyright licenses that can license or authorize any reuse of a copyrighted material. So it can be a photograph as well, but this does not cover the right to data protection. So it's quite complex because a photograph benefits from different type of protection. But what I want to say here is that it's not publicly available, and we see that very often. And we see that in different contexts that research data sets, they are publicly available. They are not publicly available in the legal sense. So the practices of Clearview AI, and I will explain that, infringe most likely the principle of transparency, lawfulness, so that's the legal ground, fairness, but also purpose limitation and data subject rights, in particular the right to information. I want to say that these arguments also come from the complaints written by Noib and Privacy International complaints. And I can give you the reference if you're interested, because they made a very detailed legal analysis under the GDPR, the practices of Clearview AI. So if I take the principles, we have a principle which is transparency, and according to that principle, individuals, they should be notified that their data were processed. And here it's certainly not the case. So there is not that much doubt that this principle is infringed. Fairness, and I think this one is very important. It means that normally your data, they are processed in line with the expectation. So if, for example, you put your data on your profile on Facebook, you don't expect actually to get access to your data. That's not something that you expect. And you certainly don't expect a company to scrap your data and to resell access to their database to law enforcement authorities. So for the fairness principle, most likely, that there is not that much to convince that the practice is infringing this principle as well. Lawfulness. Lawfulness means that you need to have legal grounds to process personal data and as well sensitive data. And I will detail this a little bit more. So what we know, and it's obvious, is that Clearview AI did not rely on consent to scrape the images. Of course, it tried to argue that since the images were publicly available, individuals, they actually could expect the reuse of their images, and they had somehow surrender any rights that they had on these images, which is absolutely wrong. But it's consent, definitely consent. There are other legal bases for which you could process personal data, and one of them is the legitimate interest of the controller. And Clearview AI mentioned in a previous version of its privacy policy. It's not anymore available on its website now. There is no mention of the GDPR. Previously, Clearview AI said that the processing was necessary for their legitimate interest. But the problem is that the interest of Clearview is purely commercial. So they don't have, they are not pursuing an interest that will be in the for the public good, for example. The data that are processed, some of them are sensitive data as well. And it's absolutely not in line with the expectation of what can be done with own data. So on this, of course, we have a test that has been developed by the European Court of Human Rights. But what I want to say is that most likely the argument that Clearview AI process data according to its legitimate interest will not be valid. And a reason as well is that you have to balance it with the data subject rights. And I think that there is no reason why we would consider the Clearview AI pursue legitimate interest by scrapping the pictures. The next one, and I wanted to add this because there is a confusion here regarding publicly available. So as I said, Clearview AI argued that they were just processing publicly available data. So it's true that for sensitive data, there is an exception. The Article 9, paragraph 2 provides a list of 10 exceptions, and of them concern the processing of sensitive data when the data have been made publicly available by the data subject themselves. I'm saying that because there is often this confusion, and making available public data yourself means you disclose voluntarily and you are aware of how they could be used. This exception has to be interpreted narrowly. I want as well to add this exception will not be sufficient to process biometric data or sensitive data that will be available on the site or on your website. There should be still there are legal grounds to process data. But I want to say that it's very important to keep in mind that the fact that data have been manifestly published by a data subject, made public, simply means that data are downgraded from sensitive data to regular personal data. So and it doesn't apply here. I don't see how this exception could apply. but it's important to keep this in mind because of the reference publicly available. Next, yes. So, sorry, I'm just coming back to this because there is something that I didn't mention, is the principle of purpose limitation. Of course, the practices of Clearview AI will also infringe the principle of purpose limitation, and the data that you publish online yourself or someone, because sometimes the pictures they are published by third parties as well. On Facebook, for example, that's the case, or on other social media. It's when these data are published, there is no way that you can reuse them for purposes that are completely unrelated without justification as well. So the principle of purpose limitation will also be infringed. And I think from a data protection perspective, what could be problematic is the right to information. You have to be informed that your data have been processed, but this right to information is also triggering all the other rights, such as your right to complain, to remedy in case someone process your data without any legal ground. So this right, there is no way this right is exercised. And I want here to highlight that several complaints for data protection authorities, they started with a complaint by individuals that asked to have access to their data. So they were not informed, but they asked to have access to their data, and that they started legal complaints. So let's move now to the law enforcement use. So BuzzFeed's news revealed in August 2021 that several police forces had tried the tool. I don't say that they use, but they tried the tool. Apparently, Clearview AI was present at a conference organized by Europol or Interpol. It's one of the two. Sorry, I don't have the exact information, but it was no, I think it's Europol. It was a conference organized by Europol. Clearview AI was present and proposed to law enforcement authorities in the EU to try the tool for free, and several did. That's the case of two Belgian detectives because it was revealed by the press, but it's not only the case in Belgium, it's the case as well in Sweden, it's the case most likely in the Netherlands, also it has been contested, but there is a long list of law enforcement authorities that try this tool, and you can find that on Business Feed News. And the problem is actually the business model of Clearview AI. And the director of the Canadian Civil Liberties Association compare it to a perpetual police lineup and mass surveillance as well, because you end up in a database for law enforcement purposes. It will be sold to law enforcement authorities without most of the time having anything having committed any offense or any crime. So there is no reason that your image is also in such a database. Then I want to question whether law enforcement authority would be allowed to use the tool in the EU. Well, you understand that most likely not. The Swedish Data Protection Authority issued a fine of 250,000 euros against the police in Sweden for unlawful processing and failure to conduct a DPIA as well. And what is interesting is the European Data Protection Board made an initial assessment regarding Clearview AI and also the possible use by law enforcement authorities in the EU. It was in June last year. And from this assessment, there are several issues. The first one is the legality of the processing, and it's based on the Law Enforcement Directive. So it's the Article 8. Article 8 requires that processing is necessary for the performance of a law enforcement task, and it has to be based on the law. So you need a law either at national level or at EU level. And to process sensitive data, the processing needs to be strictly necessary and subject to safeguards. And here it seems extremely difficult to justify actually that necessity to process the data and use the platform. And there is also, and that's what the Swedish Data Protection Authority found for Sweden, there is no law to allow that as well. But the European Data Protection Board, which gather all the data protection authorities, is working further working on this issue. And I would point out as well, the second issue is actually the sharing of personal data outside the EU. Each time a law enforcement authority would compare a picture or would upload a picture for comparison, it will transfer this photo to Clearview AI. And this will be sharing outside the EU. So this is also problematic. And the European Data Protection Board actually qualify this database of mass and arbitrarily populated database of photographs. So there is doubts about any ground that will allow law enforcement authorities in the EU to use the tool. And there is also serious doubt, the legality. I think it's more than serious doubt. Moving to that, I can tell you what has been already decided. So we have two decisions in by Data Protection Authority. Is the Hamburg Data Protection Authority that issue an order. It was limited to a specific case, and the order is also limited to that case. In that case, the Data Protection Authority asked Clearview to delete hash value generated for the complainant picture, so only for the complainant. It was only the hash value. It didn't ask to delete the images captured from that individual from the website. And also, it did not say that the order will apply to all German citizens, residents. Sorry, to all German residents or to all EU residents. That's the problem. The second decision is by the Swedish Data Protection Authorities, but it's against the police use, so it's different case. And we have a series of complaints that are currently still ongoing, led by civil liberties organizations, so Privacy International, NOIB in Australia, but you have also in Greece, in Italy, and Privacy International made two complaints before the French and the UK Data Protection Authorities. But that's a coordinated action, and we expect a coordinated answer, but we don't know when. And the coordinated answer actually might go beyond these data protection authorities that were that received the complaints. So because the European Data Protection Board is also working on this issue, and all the data protection authorities of the EU in the EU could have the same, or could follow the same answer or decision. So if you are interested, you will find the arguments that I mentioned as well, and a summary on the IDRI website concerning this joint complaint. So I'm not going to come back, but there is a distinction between the GDPR on one side for the practices of Clearview AI, and the LED, the Law Enforcement Directive, on the other side for the use by the police enforcement authorities. So what is important is really to understand that there are two different types of personal data, and there is no legal ground as well for the processing. And outside the EU, the Privacy Commissioner of Canada and the Information and Privacy Commissioner in Australia have also issued a decision. So in Canada, they are quite similar decisions. In Canada, and in Australia, they decided that the processing by Clearview AI were in breach with the national legislation, because the collection of images was without consent and sensitive information as well. There was no notification to individuals, and there was also some question concerning the accuracy on the information. And both of them, they ask Clearview AI to not only stop the collection and storage and disclosure, but also to delete images that the company has already But in Canada, in Australia, there are still some ongoing investigation for the police trial of the tool. And as a consequence, Clearview AI has stopped well providing the tools to some law enforcement forces. In the United States, there are also proceedings that were engaged against Clearview AI. So in Illinois, for the violation of the Biometric Privacy Act, but it covers only private companies. So it's the processing of biometric information by private companies, this act. Then there is a lawsuit in Vermont, which is ongoing, and one in California by civil liberties activists for the widespread collection of California residents' images and biometric information without notice and consent. So we see in all these legal complaints as well. Of course, the arguments are similar. It's the collection of images without any legal ground, any consent. To me, and I think to many people, there is little doubt that Clearview AI are lawful. Sorry, I should have said lawful. It's not unlawful. They are unlawful. They are not unlawful. They are unlawful. Despite the ongoing actions, what is problematic is to see that the company is still developing its business and holds even more images than what it was reported in January 2020. And I think that it's a very important point to finish on. It's beside that issues, and I also didn't mention discrimination issues, and that this type of database can create. These practices, they are real threat for the open internet as we know it, because if you know that your images and everything that you post online can be scrapped and reused and shared with authorities, it can have a chilling effect on your freedom of speech or on anything that you publish as well. And with this, I'm done with the presentation. And maybe you have some question that I can answer.
Yes, Catherine, thank you very much for your presentation.